Alrighty, this we the people in news. Not attorney, not giving legal advice. Educational purposes only. Okay? So never look straight forward, always look around you, be able to protect yourself by any means necessary. Okay? Arm yourself with knowledge. Alright? Use that Second Amendment. So we're back to empower, inherit it, and the people. Okay? Now they got Kirk Law Corner. Okay? Check out his YouTube. He doesn't put up more videos on there, but to understand the basics, you need to start going back to his YouTube anyway and learn the process. Um, Obviously, during time, you learn more and more and more. And he's on Power Inherited. So we need to get back to the basics. Keep it stupid simple, but regain our standing. Okay? So let's go ahead and hear what he has to say about this, all right? And remember what I told you guys. You get arrested, right? You have a right to, well, to see if there's subject matter jurisdiction of any way, right? PC, probable cause. Where is the probable cause?
The preservation of a man's health from such practices as may produce or annoy it. I mean, talk about keeping it simple. You can't get any more simple than that when it comes to our right to health. Preservation of a man's health from such practices, anything, as may prejudice or annoy it. You got to wear a mask. Well, that violates that fundamental right from the laws of nature. Preservation of my health is my duty, not anybody else.
Am jurisprudence, 2D, Section 98. No emergency can violate the rights previously guaranteed.
Yeah. The problem is that is an improper citation because that is not what American jurisprudence says now. You have to be very careful. Like Carl said, you got to go verify stuff. You got to go read this stuff for yourself.
And I'm paraphrasing.
No, what I'm saying is that it's an improper citation as American Jurisprudence Second Edition, Section 98. They have changed American jurisprudence since 1995.
Oh.
Yes. So here it is as next to personal security. This is the second primary absolute right of the laws of nature. Asserts and preserves the personal liberty of individuals. This personal liberty consists in the power of locomotion, of changing situation, or removing one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint, unless by due course of law, which means due process of law, and the law of the land, because due process of law and law of the land are synonymous. They mean the same thing. Concerning which we may.
Now, just so you're educated on that, right? He didn't say it. But law of the land in America is common law. Okay? Any other type of law is the wrong jurisdiction.
Make the same observations as upon the preceding article about personal security, that it is the right strictly natural, that the laws of England have never abridged it without sufficient cause, and that in this kingdom it cannot ever be abridged at the mere discretion of the magistrate without the explicit permission of the laws. Here again, the language of the Great Charter is that no free man shall be taken or imprisoned, but by the lawful judgment of his equals or by the law of the land, not by statutes, not by code.
Sorry about that. It is what it is. But yeah, we got to get back to basics, people. I don't even know what to say anymore. There's just so much trickery going on wordplay going on. And, they're speaking legalese when they need to be speaking English. And moreover, I know that I'm going to be finishing up on the other parts of the suit, okay? And even then, the suits are wrong, according to the way our laws are supposed to be done. But that being said,
subsequent old statutes expressly direct that no man shall be taken or imprisoned or detained without cause shown, probable cause, Fourth Amendment, to which he may make answer according to law. If any person be restrained of his liberty by order or decree of any illegal court, or by command of the king's majesty in person, or by warrant of the council board or of any privy council, he shall, upon demand of his council, have a writ of habeas corpus, to bring his body before the court of the king's bench or common pleas, who shall determine whether the cause of his commitment be just, and thereupon do as to justice as shall appertain. Okay? Habeas corpus, writ of habeas corpus. Of great importance to the public is the preservation of his personal liberty. For if once it were left in the power of any, the highest magistrate, to imprison arbitrarily whom he or his officers thought proper, as in France it is daily practiced by the crown, there would soon be an end of all other rights and immunities. Some have thought that unjust attacks, even upon life or property, at the arbitrary will of the magistrate, are less dangerous to the Commonwealth than such as are made upon the personal liberty of the subject. To berave a man of his life, or by violence to confiscate his estate, without accusation or trial, would be so gross and notorious of an act of despotism as must at once convey the alarm of tyranny throughout the whole kingdom. I'm here sounding the alarm of tyranny, folks, that our personal liberty is being deprived arbitrarily and is a form of a despotic government.
So, to dig a little deeper, and he may explain it here in a second, the Corpus Christi, right? If you go to jail before seeing a probable cause hearing, does your attorney actually file a Corpus Christi to say, hey, wait a minute, he's in just imprisonment, right? Because even our codes, right? You must be taken directly to the nearest magistrate. That's before jail. So if you go to jail first, then the very first thing the attorney's supposed to do is file a Corpus Christi, because they violated the right of due process of be heard for the probable cause. You're not supposed to wait 6 months, 3 weeks, 4 months, and be bonded and all that. You're supposed to see it before you go to jail.
Now listen to this right here. By confinement of the person, by secretly hurrying him to jail, where his sufferings are unknown or forgotten, is a less public, a less striking, and therefore a more dangerous engine of arbitrary government. That is
and that's exactly what they... Oh, well, shit, I ought to let him finish. Probably saying the same thing. Isn't that exactly what they're doing? They don't even let you... Some of y'all don't get to know and find out until after you need to call an attorney or get a bond and all that before you even see probable cause. That's the reason. And again, I liked Fletcher, but he's still not following the right due process, right? Before they come and see him, they need to see the probable cause hearing before they go to jail. But everybody's going to jail first.
Exactly what they do. They call us, label us sovereign citizens, and they arrest us and take us to jail. Well, wait a minute, due process of law is you have to take me before a magistrate. You're executive branch and you're making an arrest without a warrant. Either with or without a warrant, the Fourth and the Fifth Amendment require an immediate oversight of the judicial branch. And if they don't, that's what the writ of habeas corpus is about. To bring the body immediately before the judicial branch for oversight. Now, see, this is the unique part of our form of government. The way ours works, it technically speaking, at all times, takes all three branches working together to make this work lawfully, full of law, following due process of law. The legislature creates, the executive executes, and the judicial adjudicates. But each one, due to separation of powers, has the power to provide oversight of each of the other two. So again, the legislature provides oversight of the executive and judicial. The executive provides oversight of the legislative and the judicial. This is why the bailiff is supposed to be in the courtroom. This is also why there's called a sergeant at arms in the legislature. That's the executive branch in the legislature and in the judicial. The sheriff is supposed to be the bailiff, and he's supposed to ensure that the judge doesn't step out of line, and that any prosecutor, which we are the prosecutor. I can show you that even in my own Idaho Criminal Practice Act is, well, wait a minute, the prosecutor and his counsel, they're talking about who the defendant can demand that only certain people, exclude certain people from this initial examination, initial appearance. Well, it says except for the judge's clerk, the prosecutor and his counsel, the attorney general, the county prosecutor, and the officer holding the defendant. Well, wait a minute. Well, who is the prosecutor? And why does the prosecutor have the right to the assistance of counsel? And it clearly isn't the clerk, it isn't the attorney general, and it isn't the county prosecutor. So who in the hell is the prosecutor and their assistance of counsel? We are the complainant. This goes all the way back to common law, that we have the right to lay these complaints and be the complainant. Common law terms, words. It's in Wisconsin Constitution, Article 1, Section 21, Declaration of Rights, rights of suitors. We all have the right to prosecute our own claims. I've also found it recently here and these are current constitutions. In the Michigan Constitution, the same thing. We all have the right to prosecute our own claims. There is no distinction between civil and criminal. Plain and simple. We have the right to be the prosecuting attorney. We also have the right to be a defense lawyer. One is offense and one is defense. Plain and simple.
Alrighty, and we're getting towards the end. I don't know what else he's going to say. But, again, people, we need to go back to the basics, right? The Constitution has clearly established everything. Now, they'll go ahead and pass statutes, but does the statutes comply with the Constitution? And this is what we're seeing on these other videos, right? These discrepancies of all these statutes that's violating these other statutes to violate the Constitution. And they made it so complex that even attorneys gets lost in it. And they're supposed to be educated in these things. So they keep it stupid simple. Next thing you know, you're in jail. You don't get to see your due process of the probable cause before you go to jail, right? We're not supposed to be on record for a lifetime. And yet every single officer has got your whole history. Especially if you are being found innocent in the said case. It's supposed to be wiped out. They're not supposed to have it on their little computers. Right? Oh, he got busted for being armed with an illegal gun. You go through the courts and find out that, oh yeah, no, he's innocent. He had the Second Amendment right. Or he had a permit or whatever. But the police officer still has on the computer that you arrested for an illegal weapon. And never says that you was ever found innocent. Now, even if they're going to do that, don't that thing need to be noticed that even though he was arrested for this charge, from the due process, he's found innocent. But it never shows that. So the officer is always going to be on high alert due to false information. Well, at one time, true information. But since he was found innocent, it goes back into it was an unlawful arrest, and that's false information. All right, these are We the People News. Bye, y'all.